step in. Pardon my voice, I'm battling a sinus infection here, but we have a great program with Gary Bledsoe and Chad Dunn on redistricting for you. Before we get to that, a couple of announcements. Early voting has started in Harris County. I'm sure there's some other elections throughout the state too that are important. For all those in Harris County, this is a low turnout election. It's on HISD issues, but it's very important. Early voting goes through December 11th. There's some great candidates like Ann Sung and Sue Dygard out there, and I'd urge all of you to early vote before December 11th on that. A couple weeks ago, we had a great program that was put together by the Center for Reproductive Rights. They're the lead lawyers on the abortion front and argued in front of the Supreme Court today. I got a chance to listen to about the last 20 minutes of those oral arguments, and I was not encouraged. It's pretty concerning. We've invited Drusilla Tigner here today from Planned Parenthood. She's the Deputy Director over Strategic Campaigns and Partnerships at Planned Parenthood Texas Votes. She's also an attorney. Prior to joining PPTV, she was at the ACLU of Texas and led the Sexuality and Gender Equality team, responsible for policy and advocacy on abortion access, reproductive freedom, LGBTQIA, and equality. Prior to joining ACLU, she was a practicing attorney specializing in consumer protection and a community organizer. She holds a law degree from William & Mary Law School and a BA in government from the University of Texas. She lives here in Houston. She's going to give us about a 5-minute update, and then I'm going to introduce you to our panelists today for the program. Drusilla?
Yeah, thanks, Steve. Hi, everybody. As Steve said, I'm Drusilla Tigner. Some of you might know me as Drew, and I'm at Planned Parenthood Texas Votes, and I'm really excited to be here today to talk to you a little bit about what is going on with abortion access, both in Texas and nationwide. As Steve said this morning, there was a landmark case, or what will prove to be a landmark case likely, heard in front of the Supreme Court today. That's Dobbs versus Jackson Women's Health Organization, or JHU, as it's affectionately named or called in the abortion rights movement. This case is about a Mississippi law that would ban abortion at 15 weeks gestation. If you're on the CLE from 2 weeks ago, I'm sure that the Center for Reproductive Rights walked you through that a pre-viability abortion ban in this country is unconstitutional. The current law under Planned Parenthood versus Casey and Roe v. Wade makes it really clear that a state cannot unduly burden the right to abortion prior to viability, which is about 24 weeks gestation right now. 15 weeks, last time I checked, was prior to 24 weeks. And so this should be a really clear, open and shut case where the Supreme Court really shouldn't have taken it up, because the Fifth Circuit said that this was an unconstitutional, clearly unconstitutional pre-viability abortion ban. The court did take it up, which is what's gotten the entire abortion advocacy, bar, but also, movement worried about what the court intends to do, because there was no real reason for them to wade into this issue and into this case right now. They shed some light on this morning. The CRR was, as Steve said, argued the case, and they did a wonderful job. It looks like that the court is potentially considering changing the viability standard. There's lots of reasons why that would be an issue. Not least of which is if viability is not the standard, where you cannot unduly burden abortion access prior to, then what is? There was definitely a debate about 15 weeks and who gets an abortion after 15 weeks. And I want to say, those conversations are not productive. Every abortion that happens is a needed abortion, and that every single person who has an abortion should have the right to decide if and when they terminate their pregnancy. And just because you happen to get an abortion after 15 weeks doesn't make that more or less necessary than an earlier term abortion. And so there's some real concern about this idea of shifting this line of when abortion is legal. The state of Mississippi asked for an outright overturning of Roe v. Wade. And that's not a surprise. The anti-abortion movement for years has been trying to overturn Roe v. Wade, really since it was decided. In Texas, it would have dire consequences. Right now, this last legislative session, we passed a bill. It was what is called in the movement a trigger ban that would ban abortion as soon as Roe v. Wade and Planned Parenthood versus Casey are overturned. And that would mean that abortion would be criminalized in Texas if the court were to do what Mississippi asked them to do today, which is to overturn Roe v. Wade. And to really their stance is it should be thrown back to the states. But we know that the state of Texas and many other southern states like Mississippi cannot be trusted to protect our fundamental rights and our right to bodily autonomy, and it would be disastrous in Texas. I will say another key point that was brought up today was the idea, that right to abortion was founded on the concept of the right to privacy. So the right to privacy was talked about throughout today in oral arguments. Right to privacy gives us the right to access contraception. It gives us the right for folks to be in same-sex relationships. It gives the right to, to marry if you want to marry somebody, if you're want to enter into a same-sex marriage. So it is the foundational right for many, many of the things that we care deeply about in this group and in Texas and nationwide. So if there is a continued conversation about overturning the right to privacy, it does not just impact abortion rights, but impacts many, many other things. I think that would be devastating in this country. So we're hoping that the Supreme Court will do its duty, uphold its precedent, and not overturn Roe v. Wade. But I'm not encouraged based on the arguments that we saw today, and with the 6-3 conservative majority in the court. We're looking at dire times, to say the least. I do want to mention a couple other things, specifically SB 8, the 6-week abortion ban, which I know that you all talked about recently. We're still waiting. We haven't heard from the court yet. We hope to hear from them anytime. We definitely hope to hear before the end of the year, but we don't know. As a reminder, that case is not about whether or not a 6-week ban is unconstitutional. It is more about the procedural posture of the case. And so it's not going to strike directly to the heart of the Roe, no matter what the court decides, but it's still very, it's essential. And right now we're over 90 days in the state of Texas where people outside of 6 weeks gestation have not been able to get the fundamental right and fundamental access to healthcare that they need. I also want to mention, this is the last thing, SB 4, which was passed during the second special session, would ban the medication of abortion after 7 weeks gestation. Right now, you can get medication abortion under the FDA label up to 10 weeks gestation. And the unique thing about this case or this law is that it criminalizes a violation of it. It is a state jail felony right now, or will be a state jail felony starting tomorrow in Texas, to provide an abortion medication after 7 weeks gestation, and to mail abortion medications to anybody who needs it. In this case, it'll, there's something called self-managed abortion where people will often get abortion drugs sent to them in the mail. This would criminalize that and criminalize what a lot of people are doing to try to mitigate the harm of SB 8. And so we are in dire time here in Texas, and there's really no sugarcoating it. We're at a point where the Supreme Court could institute a ban as soon as the summer. If they overturn Roe v. Wade in Texas, we already have a 6-week ban in place. We have the medication abortion ban, even if the 6-week ban is overturned. Things are not looking good. And so I hate to, leave you on that sad note, but I do want to say that there are things that you can be doing right now to support abortion advocates. The first thing you can do is go to pptexasvotes.org. That is my organization. We are the political arm of Planned Parenthood organizations in Texas. We fight every single day in both the state legislature and in the election arena, and we would love for your support, either in donations or in volunteering. We need volunteers to be able to knock on doors and make phone calls so that we can get people elected in the state that will actually support our rights. The second thing I'm going to encourage everybody to do is go to lilithfund.org. Lilith Fund is the Houston area abortion fund. They help people get the funds they need to access abortion, which is so essential in Texas, where insurance cannot provide funding for abortion, and many people have to go out of state right now. The last thing is I will mention AVOW, which is another amazing political organization that does abortion work. I think if you support anybody who does abortion work right now in Texas, it would be greatly appreciated. And so that's it. Thanks, everybody.
Thank you, Drusilla. And if you could please put up the links for donating to those in the chat.
Yeah.
And it is concerning in dire times, and it sort of leads to our next presentation, because in both the abortion arena and every other arena, we seem to have something like 60 or 70% of the majority is being overruled by 30 or 40% of the people in power who don't represent the true majority. And it's a real problem. It leads to problems all across the board, including the abortion issues. So we have two great speakers today on redistricting. We've got Gary Bledsoe, he's the president of Texas NAACP. He's held that position since 1991, specializes in public interest law, employment and civil rights law, and has a long-standing relationship with NAACP National as a member of their board since 2003. He's currently chair of the National Criminal Justice Committee of the NAACP. He also is our last year's recipient of the Clarence Darrow Award for all of his great legal work he's done over his career. And he's an all-around great guy. And he's going to visit with us after Chad Dunn speaks. Chad Dunn is widely considered an expert in voter appropriate apportionment and redistricting for districts of political offices, as well as civil rights cases in general. He's lectured to audiences all over the country. In 2003, he was appointed general counsel to the Texas Democratic Party. He is a frequent interviewee on Fox, MSNBC, and with Washington Post, USA Today, Houston Chronicle, and Miami Herald. He graduated from UT and went on to earn his law degree from the University of Houston Law School, South Texas College of Law. And I'm going to turn it over to Chad now, and then Chad's going to turn it over to Gary. During the program, if y'all have questions that come up, put them in the chat, and we're going to have about 10 minutes, maybe a little bit more of question and answer at the end, but go ahead and put the questions up as you think of them. Chad, good morning or afternoon, and thank you.
Thank you, and thank you for including me today. Hopefully I've got some slides shared here today. Of course, since this is a CLE presentation, I was going to spend a little time talking about the law, and there's a lot of very specific laws that relate to redistricting and voting rights. And there's been a lot of changes to those, frankly, over the last 10 years. In fact, I'd venture to say next to the 1960s, the last 10 years has had more changes in voting rights law than sort of any other decade in the country's history. So I was going to cover a bit of some of that and then show you some maps, principally in the statewide redistricting maps, talk a little bit about what happened in the last decade redistricting, and highlight some of the areas of the map that will be getting attention in this decade. There's a case presently pending, a number of cases, I should say, have been consolidated before a special 3-judge federal court in El Paso. Judge Guadarrama, the El Paso United States District Judge, is kind of the managing judge of that panel, an Obama appointee. Judge Jerry Smith, a Fifth Circuit judge, a Reagan appointee, if I recall correctly, is also on that panel. And then Judge Brown from Galveston, that many of us have dealt with there, is the 3rd judge, United States District Judge on that panel, a recent Trump appointee. So that's the court that will be taking up the statewide redistricting case this cycle. It shares one overlapping member from the last cycle, and that's Fifth Circuit Judge Smith. And so a lot of kind of what happened before applies to what happens now. So let's just get right into it. There are some basic rules with regard to redistricting. This is typically even the order of precedence that it has in Texas. But the first is what we call the one person, one vote rule. It requires that when you draw new political districts, for most districts, not all, they have to have equal number of people in them. For Congress, the number has to be nearly exactly the same as reasonably practicable. And for other races like state legislative races or county commission and school board, that sort of thing, they have to be within a 10% deviation. So one district can't be greater populated than other districts such that the total deviation is greater than 10%. That's called the one person, one vote principle. It comes from a series of cases in the 1960s called Reynolds v. Sim and Baker v. Carr. That is where redistricting starts. When the new census figures come in, the map is drawn up, dividing up the population, whether it's the state of Texas when we're talking about the legislature, or the Houston Independent School District, if we're talking about the school board. We draw the number of districts that have been allotted. with an equal number of people. The next thing is voting rights compliance. We'll talk about that in a moment. Voting Rights Act compliance. The next is that the districts have to be contiguous in Texas. That means you can't have part of a House district in Houston and the other part in Lubbock. It's got to connect and be together. They got to be compact generally. Compactness is often in the eyes of the beholder. You'll see a number of maps here that have been held illegal and a number of maps that have been held legal that you might question their compactness. So that's a bit of a squishy principle of its own. Communities of interest ideally should be held together. So if it's possible to draw the State House district and keep all of the small city in the State House district, then ideally that should be preferred. And then finally, in Texas, our state constitution has what's called a county line rule that says with respect to drawing Texas House districts, the districts ideally should be drawn wholly within one county. Now, obviously, Texas is large. It has a number of counties with a very small population. So there are circumstances there where you have to draw state house districts outside the county, but ideally you're supposed to stay in the county. So those are the basic rules. The Voting Rights Act had two principal provisions that applied to Texas in this context, Section 2 and Section 5. Section 5 is what I often refer to as the defensive provision. In states that had a history of Voting Rights Act non-compliance, like Texas, was required to get permission before it could enact new redistricting plans or any other election rule. The U.S. Supreme Court in this last decade in 2013 in Shelby County versus Holder held that the method by which Congress decided which states had to get preclearance was out of date, and that Congress would need to adopt a new formula. Congress has yet to do so. So that effectively has meant Section 5 no longer exists. This will be the first redistricting cycle in Texas where Section 5 is no longer available, and it's deeply impactful. For example, 10 years ago, when Texas passed maps that would ultimately be struck down by several courts as unconstitutional, it was unable to use those maps until it got either the Department of Justice to pre-clear them or a federal district court in DC to pre-clear them. There was a trial that I was one of the lawyers involved in Washington, DC over pre-clearance, and we were ultimately successful denying Texas pre-clearance on a number of parts of its map. That had the effect of forcing the state to essentially redraw those parts of the map. So when Shelby County got rid of the pre-clearance process, it shifts the burden. Instead of the state having to get permission, it's now plaintiffs have to sue the state and get an injunction. And they would do that under various constitutional claims or Section 2 of the Voting Rights Act. Section 2 is what I call sort of the offensive provision, because it means plaintiffs have to go on offense. And that means you go into court and you file a case and ask that the government be enjoined from putting in place these redistricting maps because they are racially discriminatory. So in Shelby County, the Justice Roberts made a promise, and the promise essentially was that even though we're undermining Section 5, or essentially gutting it, because we're saying that until Congress passes a new formula, it's not in place. Section 2 remains law of the land and will remain part of the important protections that federal law provides for racial minorities. And so this is going to be the first election cycle where we see if there's teeth in that promise, if it's possible for people to go into court and obtain preliminary injunction in time to hold back racially discriminatory cases. Racially discriminatory voting cases. Shelby County had an enormous impact. A number of things happened. We had successfully stopped pre-clearance of the state's voter ID law in a trial in Washington, D.C. among 3 judges. They had found the law probably racially discriminatory in intent. As soon as Shelby County came down, then Attorney General Abbott announced that the Senate Bill 14 was going into effect. In fact, as I was coming out of the U.S. Supreme Court from the announcement of the Shelby County ruling, I had a text on my phone from Abbott saying Senate Bill 14 is in effect. So it had a real tangible effect on voting rights all throughout the country. It resulted in the reenactment of several portions of the state's map that we had successfully fought back in the Section 5 proceedings. It resulted in Galveston County deciding to eliminate Black and Latino justice of the peace districts. The city of Pasadena ultimately decided to go to a hybrid election system that had so many at-large and so many single-member districts as a way to prevent the growing Latino population there from having a political voice. Beaumont Independent School District had been successfully stopped from being taken over by some interest aligned with the Anglo community, even though it was a majority Black population. And there have been countless polling place changes, and indeed all of the election law changes you've heard of since 2013 are as a result of Shelby County. So many of these things, including the latest voting bill that the legislature passed, would have been stopped under Section 5. So the other cases that happened this year were partisan gerrymandering, this decade, I should say, were partisan gerrymandering cases. There were cases in Wisconsin, Texas, and Maryland. In the Wisconsin case, the Gill v. Whitford, Justice Kennedy was still on the court. And in that case, a lot of us thought that the Supreme Court was finally going to police partisan gerrymandering, at least the most extreme versions of partisan gerrymandering. And a number of very smart scientists had come up with objective ways to measure, from a mathematical standpoint, wasted votes, what are called wasted votes. People have been packed into districts where their vote will never really effectively count. So a lot of us thought that that was going to be an opportunity for the Supreme Court. We had finally developed a standard that could be applied as easily as the one person, one vote, 10% standard. And indeed, it sounded that way at the argument, which I was at. It sounded as though Justice Kennedy was ready to lay down that a rule in that regard, and which would have been a 5-4 ruling at that point. Instead, a limited decision came out finding that the plaintiffs in that case did not have standing and sent the case back to the district court. At the same time was pending Perez v. Abbott, the case in San Antonio with a number of race discrimination claims, but was also a partisan gerrymandering claim that I'd brought on behalf of Democrats in Texas. And there the court ultimately ruled without explanation that there was lacked a justiciable standard. And so otherwise it didn't move forward on that question. So finally, there was the Rucho versus Common Cause, which put partisan gerrymandering to bed, unfortunately, for quite a while. And in that case, the new majority of the Supreme Court, in an opinion written by Justice Roberts, ultimately found that partisan gerrymandering, although they find it abhorrent and wrong, it's too difficult of a question, and it's a political question that is just not suited for legal analysis or legal resolution. So as a result, you can no longer bring any sort of partisan gerrymandering case in federal court. There are a number of states that have protections in that regard. And there are a number of states that are adding protections, usually through their initiative process, which Texas does not have, but where you pass a new law basically by petition and election rather than through the legislature. So that partisan gerrymandering is not going to be a rule this redistricting cycle. So where does that leave us? We have the Section 2 claims that I talked about, when you can show that a district has the effect of preventing people from having an effective voice in the elections as a result of their race or ethnicity. And there are very specific requirements when it applies, but one of the requirements is that you have to be able to draw a district that's greater than 50% CVAP, we call it, citizen voting age population, of whichever community, minority community, either singularly or in coalition, that you're trying to protect. And so that's the Section 2 claims. Minority opposite, there's also intentional discrimination claims, which are often called Arlington Heights claims. And if you're interested in that test, you can Google Arlington Heights, and there's a multi-factor test to determine whether or not a legislative or congressional enactment has been adopted with a racially discriminatory purpose. There's the one person, one vote claims that we talked about. If a district is greater than the number of people it ought to be in one district compared to another. There are what called Shaw v. Reno claims, which are claims where you can demonstrate on the perimeter of a district that voters were selected on the basis of race. So oftentimes we can zoom in on a community, highlight voting precincts by the racial majority by color, and then you can sort of see, well, Latino voters were all placed here, and Black voters were all placed here, and white voters were all placed in this different district. And it's, you can literally see forensically that the law has been broken. And then it's possible that Texas or other places could be what's called bailed in. If they are proven to have intentionally discriminated, a federal court could order the state back under preclearance without Congress passing. Even though the last two cases, the voter ID case and the Texas redistricting case, the state was found to have intentionally discriminated, it didn't result in bail-in. And so there's some question of the viability of that provision going forward. So I'm just going to go through some maps real quick and hand it off to Mr. Bledsoe. But this is some explanation of some of what happened in 2011, and then some of what's at issue in 2021. But this is Tarrant County, Fort Worth. This is the state Senate map that was passed in 2011. Senate District 10 was then held by Wendy Davis. And the state had adopted this map that effectively cracked the minority community. And then you see this finger coming up of Senate District 22 came up and picked up additional minority population and buried it in rural counties. Ultimately, the court in DC, in a trial that we had under Section 5 of the Voting Rights Act, denied preclearance of the plan, and then the San Antonio court imposed by remedy this map for Senate District 10, which continued to perform as a minority opportunity district. So that was one of the things that happened in 2011. This is the House map in 2011. House District 41 was held by a Democrat that had recently become a Republican. And so the effort was to draw a Republican district to find low performing Latinos and higher turnout white communities to put together in this sort of spider district called 41 here. And the court ultimately struck that down as a discriminatory and imposed a map that looks like this one here. This is El Paso. The state had, we call this the Deerhead district. This is also a House district. The state had claimed it drew these districts to fit around the mountain range there in El Paso. But that when you overlaid the geography in El Paso, that claim didn't hold up. Instead, the district imposed the district court in San Antonio imposed this district, finding the previous version was racially discriminatory. This is the House map, the congressional map, also in Dallas, Fort Worth. And you can see a number of fingers here, CD 26, CD 6, for example, that come in and take parts of urban minority population and then bury it with more rural, largely white counties. You see 33 comes in the southern part of the county and goes out. The court ultimately struck this down and adopted a new district that's electing Mark Vesey at the present, and that's Congressional District 33. And so you'll see kind of this barbell looking district that picks up minority population in Dallas County and Tarrant County. There were some other changes in congressional districts in the South, and Travis County was split 5 ways, which ultimately the Supreme Court said was fine. So here's the new maps. Just first, the census came out. The 95% of Texas's growth has been minority this last decade. That's over 4 million Texans. As a result of this, Texas gained 2 congressional seats. If the census hadn't been gamed by the Census Bureau on the issue of the citizenship question, and if Texas had decided to put forth more effort to ensure responsiveness to the census, in all likelihood, Texas should have gained 3 congressional seats. So, and starting back in the Senate District 10, this is again what they did in 2011 that the court struck down and imposed this district. And this is what they have done in 2021. They took the same Senate district and buried it in these rural county, Senate District 10. They used another finger in Senate District 22 to come up into Tarrant County to split the largely minority population. And so it results in Tarrant County not electing a single minority candidate of choice. This is in El Paso. This is the districts that's passed and remedied by the court 10 years ago, had 5 districts in El Paso County. Bit of trivia for you, El Paso County is the only Texas county that only borders 1 county. Anyway, this cycle, El Paso was drawn and split, had one of its districts buried into 74 that had the result in El Paso going down to 4 state house districts, even though there was population growth, like Latino and other population growth in El Paso County. Travis County, recall, was split 5 ways in the previous map. The Supreme Court upheld that, but this cycle, this is the new map, the congressional map. The state redrew Travis County, instead drew a new Democratic district in downtown Austin, and that allowed it to shore up a number of Republican districts that had been used to split up Travis County but were becoming competitive. And so it is the case that Texas took 2 of its congressional districts and drew 1 for Democrats, this one here in Austin, and drew 1 for Republicans. But 95% of the growth in Texas was minority growth, and none of the new districts were drawn to elect minority candidates of choice. So there's a number of claims, many more than I've gotten through in the time I was allotted today. But obviously, we're interested to see, just as it is in the abortion cases, where it is the new U.S. Supreme Court is constituted is going to feel about remedying historical discrimination. And there's nobody that's lived that more than Gary Bledsoe, so I'll hand it off to him now.
Chad, thank you so much. I really appreciate all the great work that you continue to do with the Democratic Party here in Texas. I think you've truly made a difference, and we're going to need people like you in the future, I think, for many, many reasons. I want to applaud HCDLA for having this seminar today. I'm going to take a little bit of a different approach from my good friend, Mr. Dunn, and I'm going to talk about, I'm going to presume that many of you may want to be part of the process, that you may want to come and help because of what's occurring. And so I'm going to try to focus my comments in many ways on that. Let me begin, though, by saying I think that what we have to understand is that Texas is ground zero for what has been occurring in this country. If we take a look and go back to 2010, that 2010 census said that 49.4% of Texas adult population was African American and Latino combined. When you add the Asian and other non-white population, the white population was definitely well under a majority. And that number of minorities, as Mr. Dunn indicated, has continued to grow. And so really and truly, Texas is almost 60% minority, and particularly when we look at the voting age population. So it's a situation where 40% of our state is attempting to continue to control 60% of the state. And of course, just like the minority vote, the white vote's not monolithic. So the question is, how can you control our state with a small percentage of the population, maybe 4 out of 10 votes? And that's what really and truly they've attempted to do. Now, I want to mention 2 cases. I think Chad mentioned both of them in starting out, but I think they provide somewhat of a guide for the comments that I want to make. The one is the Shelby County opinion. And that opinion means that no longer can we send objection letters to the Department of Justice and have them tell the state of Texas that a proposed law is potentially discriminatory, so refuse to pre-clear it. And so that option now of having DOJ or a panel of judges in DC to come in as they did in 2011, we no longer have that option now. And so that's a huge problem. And the RUCO versus Common Cause case has enormous consequences for many, many reasons, because that was such an extreme gerrymander of a partisan nature, and the court allowed that to go forward. And so I think that the conservative entities around the country have taken note of this. Now, one point I want to make that's kind of an interesting point is that in red states, for the most part, except maybe Utah, they've decided to allow the legislatures to draw up their redistricting plans, whereas many of the blue states wanting to be progressive or what have you have come up with independent commissions. And so I think that's kind of an interesting difference there between Republican-dominated states and Democratic-dominated states. If we could show that the title to that first article, I want to visit with everyone about the Paul Waldman article out of the Washington Post. Not that if we could look at the other one to begin with, that would be great if we could, Mr. Mullins. Okay, the redistricting apocalypse is here. This couldn't be more accurate. I'm so glad to see that someone really gets it, because I think that many people think this may be the run-of-the-mill redistricting process that is being undertaken this year, where generally speaking, one side might take seats that belong to the other. And that's probably been the case. It doesn't matter who's been in power. But I think that what Waldman indicates is that this is very different. He's trying to call alarm to what's actually occurring. That he said in this piece that the Republican goal this cycle is to make elections irrelevant. And I think that's important to know. The whole idea is to make elections irrelevant. And what he calls the current redistricting efforts is an assault on democracy. So I think he's really got it right. And he highlights 5 states in this piece, and he highlights Texas. And of course, he talks about Texas having 24 of 38 seats being solidly white dominated or Republican, and there being one competitive seat, even though I think we saw in the last election, for example, that Texas went 46.5% for Joe Biden, but we have here about a 60-40 split when it's all said and done in terms of the differential and who controls what seats actually in Texas. So it's well beyond any kind of barrier or that would be reflective of the statewide vote. North Carolina, 11 of 15 with one competitive. Georgia, 9 out of 14. And we know that 2 Democratic senators won election there in this past January. And we do know too that President Biden did win that state. So that state was formerly a red state, but it's now become somewhat of a purple state probably, but we can see the gerrymander that the legislature did there. Utah, I had an independent commission, and that commission actually rejected that commission's plan was rejected by the legislature, which then proceeded to adopt a different plan, one that would not allow Salt Lake City to be split in different areas, because that's an area where President Biden had done well. And so it was clearly done in a manner to ensure that there would not be a Democratic voice coming out of that area. And Ohio is considered to be the most egregious, where the Republican legislature is taking 13 of 15 seats in a seat in a state that, again, is about like Texas, about 46% or so Democratic. So we can see when we start talking about 218 in Congress and reaching that number, we can see where all the prognosticators out there are saying that we're going to have a change in DC. Now, if we could look at the next piece in Galveston County, and the point I want to make with this one is that, you know, formerly we become accustomed to minority representation, and one saying that, well, if you've got existing minority seats, that's one of the things that I think Chad mentioned, that generally speaking, you would say, well, we'll protect that seat, even if it's not a 50% seat. We'll protect that seat, but we'll draw up the other seats. So maybe we'll take 3 seats out of 4, but we won't take 4 out of 4. Well, this shows that dynamic has changed. That in Galveston County, that what happened there is a minority seat that my good friend Wayne Johnson first held, that Commissioner Holmes was appointed to after Wayne had died. that they have just decided to no longer continue and preserve that what we consider to be a protected minority seat. And as what Mr. Dunn indicated, they don't have to get pre-clearance. They just do it. They did it in Baytown. They'll do it wherever they need to. And they realize that you've got to go and sue and prevail. And we have many more conservative judges. I think President Trump saw to that, and they're more conservative than I think the Bush judges, for example. So I think we realize there will be an uphill battle here. What I want to suggest is that there may be three ways that many of you might help, and that is you can learn to litigate redistricting cases, because just like we see what's happened in Galveston County, there no doubt probably going to be doing this in other counties, and so you don't have to be part of the statewide litigation. But I think that being able to help litigate those cases and join with your national firms that do this kind of work, whether it's the Legal Defense Fund, the Lawyers Committee, the Southern Coalition for Social Justice, MALDEF, or whoever it might be, I think that's important to do that. And because there's not enough lawyers in those great organizations to really cover the territory, so they need really good lawyers that people can work with to try to make a difference in these areas, and not just say that because of a person power issue that we're not going to address those matters and just allow the stealing of districts to occur. And one can even assist in redistricting cases. And I want to talk about that in a second. And then we'll talk about tell Congress to pass a new Section 4. I've been really disappointed what I've seen there, because we want to have perfect fixes, and so we're putting too much, in my mind, into the changes that need to be made. I do know that even Cinema and Manchin seem to be for this, and I think that and even some Republicans and just doing something to Section 4. I think we need to do that, because this would make the job a whole lot easier, because right now all these new laws that are being passed are going to be problematic. And so one of the things I wanted to discuss where individuals might help is one of the things last time in the Section 5 litigation in reference to Texas. Texas did the same thing then that it's doing now, and that I think all the states that are red controlled are probably going to do this time. They're going to use the partisan defense. And so that means what the state basically did last time, and Chad can tell you this, they basically stood up in court and said, yes, Your Honor, we did discriminate against African Americans. We did discriminate against Latinos, but we didn't do it because they're African Americans. We didn't do it because they're Latinos. We did it because they're Democrats. And I think they think that's a new winning hand. And when you look at what they allowed to go forward in RUCO, you understand that some of these dynamics may be a real problem for us down the road. And so one of the things that I think that the reason we won that case in DC, according to the court's opinion, was they went ahead and found that the Senate factors, or the Arlington Heights factors, actually existed in terms of proof that we presented to the court. And so based on that, they basically denied the claim that this was a partisan redistricting effort. And so I think that we have to look at things like that for this go around to try to make sure we put together data and information that will be seriously compelling. I think we're probably at a time similar to what the civil rights litigators were in back in the 30s, 40s, and 50s, when Charles Hamilton Houston, Thurgood Marshall, and others had to look at adverse judiciary and figure out ways that they could potentially win, and I think the Brnovich case out of Arizona that was just decided by the court gives us some idea as to what the court might be doing. It seems to me the court in Brnovich is saying there's a new sheriff in town, that even though we've been very conservative, that was not conservative enough. And so what we're doing is we're heightening the standard. We know that you plaintiffs have been winning cases all around the nation by using statistical evidence and analyses, but we're basically going to limit that opportunity now. We're going to say that it's got to be serious and egregious, that it's got to be more than just showing apparent discrimination. It's got to be something that's so serious and extreme that we should take action. Otherwise, we're going to basically decide that the state was appropriate in terms of what it did. And so the Senate factors talks about a number of things, and this is where even litigators and your experience and things of that nature might have great importance. The history of official voting related discrimination in a state of political subdivision, that's normally something for an expert to talk about, but it also talks about another factor, the extent to which voting in the elections of the state political subdivision are racially polarized. And we know we still have racially polarized voting, and it's becoming, in my opinion, probably more racially polarized in the states. So I think that that's another factor that the courts look at. Another is the extent to which there are voting practices or procedures that tend to enhance the opportunity to discriminate. We just saw that with our legislature. We know that the new laws that passed are extremely discriminatory, but we know that many of you volunteer for elections, and we're hoping maybe even more of you volunteer in the future, because we're going to need to be able to identify instances of problems. Some of the things that maybe, for example, many of you might have seen the Common Cause video that was leaked that clearly showed that in preparing poll watchers to go out, it was clearly a presentation that was biased or infected with bias against the African American community. So we know that kind of thing is continuing to happen. We know that the way poll watchers and others were empowered this time, and the way that they attempted to neuter election judges, there are going to be greater problems. So we want to have examples, we want to have anecdotes, we want to have as much up-to-date information as we can to really try to show the court the real problems with the Texas law that was introduced. And if there are any other issues, we want to know about those as well. We want to know about slating processes. One of the interesting things last time, we were able to show that, for example, even one of the Republican members of our panel, Judge Rodriguez, had been a Supreme Court justice, but had not won re-election because Latino Republicans were actually losing. And so we could actually show where in that kind of slating process, so to speak, Latino members did not fare as well as others. The extent to which minority group members bear the effects of discrimination in areas like education, employment, health. So if there are reports and things of that nature that you're aware of, that we want to hear that. You've had verdicts in cases, we want to hear about those. I think that's all important. Overt or subtle racial appeals and campaigns. We know that, for example, that what folks did back in, I think, the 2010 election, we found where they darkened the skin of Chris Turner, a white Democrat who heads the Democratic caucus now, and they painted in gaps in his teeth and had him with the Chinese flag and with the Mexican flag, and they did all kinds of really ugly campaigning, but we were able to use those. We even found in Galveston County signs of white cowboys kicking President Obama in the butt. So, you know, those kind of things that maybe you see, you take a picture of them, find out about them, and get that information to us, because that's the kind of thing we need to continue to identify as part of this process. Let me get down to, I think the racist campaigns where the minorities not on slates, racial incidents that occur, hate crimes, or what you see on the internet. There was so much trafficking on the internet during the special legislative sessions that many of you might have information. There was information from statewide elected officials as well as office holders that were state reps that I thought were clearly bigoted and biased, that are going to be great use for us in terms of trying to show that the Senate factors exist here in Texas. One of the issues in the Cooper case is treating minority Democrats differently. That's an interesting dynamic. I think that we need to look at the way that they have drawn the maps. I think frequently what we do find is that minority Democrats get the brunt of the discrimination, because it's the minority Democrats, for example, in Dallas County, where CD6 and others kind of snake in and take that over, or SD10, like Chad mentioned, and how they split or crack the minority community in Tarrant County there. So, but we need examples of that. And we also want you to speak out in places that you belong and work with this organization and others. I think that some of the cases I want to recommend, if you are interested in just doing some preliminary work on this, the Perez v. Abbott case that we lost 5-4, and right now we probably lose that case 6-3 based on the changes. So things have not gotten better, and we had won our case. Chad will tell you, in front of a majority Republican panel. We won a majority there, but they got overturned, and there was no real basis to overturn the decision because it was a very measured decision. But indeed, we got overturned for the most part by the Supreme Court. The Alabama Black Caucus case, I think, is important because as we talk about, especially the 50.1% issue, and where they tried to use the need to preserve minority districts as a cloak to discriminate against minorities by packing them into minority districts. And the Cooper case that I mentioned earlier in reference to this, some important discussion there about the different treatment between Black and white Democrats. I think that's important. Bartlett v. Strickland is another case I would suggest that you take a look at. And I think what that talks about is that when you're required to draw districts in the 50.1% requirement, but it clearly discusses the issue of joining African Americans and Latinos together, or minorities together. And it says that decision hasn't really been made by the court. That's one of the big issues that may be coming up this time, because there are many more seats that can probably be drawn if you join Black and Brown, or Black, Brown, and Asian together. And so being able to show that they are politically cohesive and have really common socioeconomic interests is going to be extremely important going forward, and trying to get more seats that might represent the minority community. The RUCO case, obviously, that we've discussed, is an extremely important case. And ironically, we talk about the issue with Roe v. Wade, where we're seeing where the court's probably going to react and in an inappropriate way will probably at least limit Roe. I don't know if they'll completely overturn it, listening to some of the argument today. But I think in the RUCO case, that's a case that we're going to have to revisit ourselves. We've got to come up with the standard. We've got to have some kind of way to police this whole issue of partisan redistricting, or else elections really won't matter. And Thornburg v. Jingles lays out basically the requirements for how you, and I guess I'm finished. That's the cue. So those are kind of the cases I'd say to look at. And thank you guys so much for being interested in this topic.
So, sorry to cut you off, Gary. I just want to make sure we have a few minutes for question and answer. And by the way, for the 135 or so people who are online right now listening, we're going to go about 5, maybe 10 minutes at the most over today, because there's a lot of interest in this topic, and it's such an important topic. People have asked Gary how they can help in this fight. And in addition to volunteering here in Harris County with the Harris County Democratic Lawyers and with the party, headed up by Nicole Peterson, who's doing voter protection, and we're going to have a really strong effort in March. Contact us. We'll put you in touch with them. If you want to work in the litigation arena, we'll put you in touch with Gary and others who are working on it, and Chad statewide, who we're working with. And I've neglected to mention at the beginning of the program that we are very grateful to Chad Dunn for working with Harris County Democratic Lawyers and one of our co-founders, Leah Rolano, in launching the Texas Democratic Lawyers Association. And we're starting chapters all over the country, all over the state. And we've had a lot of interest in that all over the state. And we have people tuning in from all over the state today, as we do with many of our programs. I would urge you to contact us if you want to find out how you can get a chapter going in your area, because one of the biggest efforts we're getting behind is voter protection. And it's going to be so important, especially with all these new laws that they've passed that allow people to go in and harass others in the voting place. We're going to need a lot of lawyers in that effort. So thank you, Chad, for that. And the first question, Chad, I think this is, this is probably aimed at both of you. This is from Jerry Bernberg, the former chairman of the Harris County Democratic Party. He wants to know, because you mentioned Jerry Smith earlier, I believe, Chad, Judge Jerry Smith. He said in the 34 years he's been on the Fifth Circuit, has he ever voted for Democrats in a redistricting, voting rights, or election law case? And Chad,
I don't claim to be a complete expert on his record, but yes, he has. In the 2011, or I think it was, the 2011 San Antonio trial against the state, Judge Smith joined with the other two members of the panel to find the map discriminatory. And in particular, I think the quote was something in the Dallas-Fort Worth area. And some of those maps I showed earlier, I think the quote from the court from Judge Smith was something like, there's very little of the map drawing in Dallas-Fort Worth that passes muster, with the use of those lightning bolts to sort of grab minority population and bury it in rural areas. So that's the one I could think of offhand, but it is a fair point that he is typically very conservative when it comes to voting rights. And he was the judge that wrote the opinion denying Texans the right to vote by mail during the pandemic. Even though it's allowed for people over the age of 65, the U.S. Constitution prohibits age discrimination in voting, the 26th Amendment. But Judge Smith said, it didn't. In fact, the opinion says it's acceptable for the state to make voting easier for some people based on their age than others. So yes, he's very conservative on voting rights, but there's been at least one ruling.
Okay, and we had a second question from Jerry, and that's, what's the status of the Harris County Commissioner's Court redistricting case, and what are the arguments Republicans are making in that case?
So there's a state court case pending by the two Republican commissioners and some voters. They essentially argue that there is a state right to vote, that the state constitution provides for the right to vote. And there is what constitutional scholars call a free and fair elections clause in the Texas Constitution. It has not historically had any teeth to it. As you know, Texas has had a sordid history of denying the right to vote to its citizens. But the effort, it looks to me, is to create and carve out a new rule in state court that says that when you draw redistricting maps, you have to change them as little as possible to comply with the one person, one vote principle. That would be news to leaders all over the state of all partisan persuasions, but that's appears to be the argument they're advancing at the moment now.
Okay, and we have another question. This one's from James Darty, who's here locally a lawyer. Can legislators redistrict congressional districts or other districts mid-decade, as was seemingly done with Tom DeLay's action in the mid-90s?
Gary, you want to take this one?
Sure. The answer is yes. I think that they are obligated to do it again in 2023. The way I read the state constitution, they're mandated to redraw lines the first regular session after the receipt of the census data. And so I don't think that the regular sessions met that requirement here. So I know there is a lawsuit that was filed to challenge the legislature's authority to actually redistricted in 2021. Now, Chad might correct me. I don't think the judge has actually ruled on that part of the opinion, but I think at the state of where we are with it, I don't think that the judge is likely to take any action that would invalidate what the legislature has done since the election's already started. So I think we can presume that that will not be overturned, but I think in 2023, not only can they do it, but they're probably obligated to do it. And what the delay case decided was the same as what they decided in Pennsylvania, the U.S. Supreme Court. You can do it mid-decade.
And I have another question for you. If the California legislature was as cutthroat as the Democratic legislature has been in redistricting, what sort of apportionment could there have been in California as far as the number of reps representing the population as we may have in Texas if this survives the litigation?
I'm happy to take that. I've happened to actually look at that. So California has a commission system now. So its maps are drawn by a so-called nonpartisan redistricting commission. I usually refer to it as an unknown partisan redistricting commission because in these days and ages, it's hard to constitute a group like this and people who want to be on it that just have no partisan views. But in any event, they draw the map for California state legislative districts in its congressional map. I have seen maps that reduce the California congressional delegation down to one Republican. So if the legislature there wanted to engage in the kind of redistricting process that Texas does, it could eliminate quite a few Republican districts. And so there's people who are essentially arguing that, look, in the world where there's not going to be any rules, where the Supreme Court says there won't be any referee on this stuff, does it make sense for other states to engage in the same sort of partisan redistricting? Now, the problem with that, there's probably several problems with that depending on your perspective, but one of the problems with that is oftentimes to draw a map that is aggressively democratically partisan, you end up being racially discriminatory. So, I think in order to get the California map to a place that was down to one or two Republican congressional seats would almost certainly dilute minority communities, and in my opinion would violate federal law. But again, if California was willing to have the same view of the Voting Rights Act as Texas, I think it could be extremely aggressive in eliminating Republican districts.
Okay. Guys, we've gotten a lot of comments that this has been a fantastic program. We've also gotten a lot of comments that we're a real downer today. This is pretty depressing. Do you have any final thoughts you can leave with everybody that maybe on an upbeat note? Is there any silver lining here? Is there anything good here? Or is it all bad coming down the pipe?
Well, I guess I'll follow if you don't have something nice to say, don't say anything at all. Unfortunately, I can't be the upper, but hopefully Gary can.
Well, I know we've had discussions, for example, in reference to, I know a number of the plaintiffs' parties have thought about trying to bring claims where you don't raise various constitutional issues so that you can avoid a three-judge panel, and so therefore you can go through the Fifth Circuit. I think that there is some level of sensibility on the Supreme Court. I know that sounds really strange for me to say, because I think it is an activist court. I think it's an extreme court. I think it's probably the most extreme in recent years, and I thought it was extreme before. I think that when Kennedy left, that really tilted the balance, and now we've got really solid conservatives. But in Bernavik, you see Clarence Thomas and others that continue to bandy about talk about the unconstitutionality of the Voting Rights Act or what have you, and they haven't gotten takers. It was kind of today where it seemed to me, just listening to the Chief Justice, that he knows that Roe may be about to be eliminated, but he doesn't want to see it overturned. So I think he was trying to navigate and get questions as to other viable ways that one could look at it. Though we would lose something, we wouldn't lose everything. And I guess that's the only way to look at it, right? And that is, we have to really come and think, what is the common decency that we can reach some of these individuals? And I think many of you, just great litigators, people that have experienced life yourselves, you may come up with good and great thoughts for us in terms of providing some kind of guidance. So I think that there's some humanity. I think there's one or two of those conservative judges that might be reached. I think there's probably 3 or 4 that there is no way to reach. Thomas Alito, I think there's no way to reach them. I think Gorsuch has one demeanor, but I think Gorsuch was one of the ones that, with the partisan standard, poked fun at it when the case was argued or what have you. So I think that that's a real problem there, because instead of being serious, because I agree with Chad, I thought what they put forward was really worthwhile, but they actually joked about it during argument. So I think there's some hope. We just need to find out where their souls are and try to reach it. I mean, that's kind of where we are. Let them know what's at stake, because I think that somewhere down deep that many of them might believe in our system of government, might believe some of the things they might have learned in civics years ago, and that might be something they don't want to cross. We've got to be able to paint that picture to them to let them know that's what they're doing. We got to somehow bring over to our side, but we're going to lose some. There is no question. I mean, I don't have any illusions. We lost Perez v. Abbott 5-4, so there's no way in the world I think we're going to sustain any kind of big verdict. But the thing that Chad laid out, I don't think there's much chance that we're going to win this time in front of the 3-judge panel. We did last time, and on Judge Smith, Judge Smith was really trying to be very objective and all that the first time. It's almost like someone grabbed him after that first opinion. I don't know if you noticed that, Chad, but I think he was a different judge after that 2011 trial.
Any closing thoughts, Chad?
No, I appreciate the invitation. Thanks for having me today.
All right. Thank you, Chad. Thank you, Gary. Thank you for everything you do. I'd urge everybody, don't just sit back and be depressed about what's going on and throw in the towel. Get out there, get involved, volunteer, run, do something, and help us with the voter protection efforts that we're really going to need a strong effort with in March. And you can contact Nicholas Spencer at Texas Democratic Lawyers, or Rose Clouston, who works with Chad at the party in Austin, and we'll hook you up in your various counties. If you're in Harris County, contact us at Harris County Democratic Lawyers, and we'll set you up with Nicole Peterson, who's heading up the voter protection efforts there. And they're going to be very important in the upcoming primaries in March. Thank you, everyone. I'm sorry we went a little over. We will probably see you back in January, and have a good holiday season. And thank you for everything you do, guys.